So evictions happen when things go wrong. I think that's pretty obvious. What's not obvious is what landlords can do to minimize their losses if they have to evict, and then what steps should be taken in order to never, ever have to file an eviction. We're talking all about that today. Let's get started. So I'm a landlord attorney in the state of Texas, so I'm going to use some Texas data to help prove a point. First, in Texas, there are about 4.15 million rental units for residential purposes. So we're going to use a nice round 4 million units number. And what we know from last year's numbers is that there were about 200,000 evictions filed. So out of 4 million rental units, that's about a 1 in 20 or a 5% eviction rate. Of all the leases that are out there, 1 out of 20 went to an eviction. But I can guarantee you that if there were that many evictions filed, I promise you there were more than that in terms of notices to vacate. And I would further argue that for every notice to vacate, which were many more than 200,000, there were even more actual defaults. And so the real question for landlords isn't how do I file fewer evictions? It's more how do I deal with default in a way that results in fewer evictions and less lost money? Because it's also evident just from a data perspective that the more evictions you're filing, that probably means the more money that you're losing. If you're having to resort to an eviction at the end of a long struggle with a tenant, it's probably going to result also in massive losses from that tenancy. And sure, you may be saying, well, I've got another 19 leases that are floating this one where I had to file an eviction. But something tells me that even if you're not filing in those other 19, you're still experiencing instances where you've issued notices to vacate, or you're still experiencing instances where repeatedly you've had instances of default. So this isn't just about stopping eviction or preventing loss exclusively from eviction. Eviction is really the last step. Instead, this is about going before the eviction process in order to save money down the long haul. Stick with me all the way to the end of this video, and we'll see if we can't find a better way for you to minimize your losses from, let's just face it, a tenant that must be evicted, and then minimizing those defaults that ultimately lead to eviction. So one surefire way to reduce your losses in any eviction is quite simple. You have to evict faster. If you're waiting too long before you begin the process just to find out that the process itself is not instantaneous, you're going to be frustrated by the additional losses. So what we find is sometimes landlords use a frustration point as opposed to a trigger point, or that is to say, their trigger point is the point in which they are frustrated. And I want to tell you that from a managerial perspective, that's not a good idea. Don't wait to get so piping hot mad that all you're left with is to file the eviction. It's probably way too late at that point. Instead, what you need is a definitive trigger point. What we know is that once a tenant falls more than a month behind in unpaid rent, the likelihood of recovering any amount of that unpaid rent is extremely low. In fact, in many situations, a landlord is found to have evicted a judgment-proof tenant. That is to say, they have no assets, they have no accounts, they have no source from which that judgment can be collected. Now, in different states, there are varying options for collection. In the state of Texas, for example, a landlord simply cannot seize the wages of a tenant, even with a fully valid judgment. In other states, that is possible. Depending on the debtor rights in your state, you may find yourself with a judgment that simply has no value beyond the paper that it's printed on. And so getting a judgment is not itself, except for the fact that you need it in order to recover possession, where the debt comes into play, getting a judgment is not itself the solution. Instead, by acting much faster in the process, you minimize the number of months of lost rent that you accumulate. Remember, you should have some form of a security deposit to protect you against some loss. It's unlikely that your security deposit is going to relieve you of all of your economic losses when you are forced to evict a tenant. The sooner you begin your eviction process, the likelier that security deposit will cover your eviction losses. But Ernie, what can I do in order to speed up the process? If you go backwards from the eviction filing, the step that precedes that is the eviction notice, often referred to as the notice to vacate. And really, there's a sweet spot when it comes to the notice to vacate. Some landlords issue notices to vacate so often and so quickly in the process that it essentially waters down the value of the notice. If a tenant receives a notice to vacate every month because they tend to pay on the 5th or the 6th, but they have never been evicted, guess what? Receiving the notice to vacate simply does not have the same impact that it would if they get a notice to vacate and it is followed up by an actual filing. So my suggestion is that you don't issue a notice to vacate unless you are going to file, that you are substantially certain that that tenant will be removed, barring some miraculous turnaround. So a landlord or a property manager should not wait until a point of frustration before a notice to vacate is in fact delivered to a tenant. Instead, a landlord or property manager should have in place a pivotal point in time in the process where it is essential that a notice to vacate be delivered, and that it is nearly certain that from that notice to vacate, an eviction case will be filed. Now that assumes, of course, that the tenant has not vacated, and it assumes, of course, that the tenant has not rectified everything perfectly. We'll talk a little bit about how that can be accomplished and when it makes sense to accept funds or accept cure from a tenant even after they have passed that breaking point. So how do you draw a line in the sand, one that you know is coming, one that the tenant can inspect, and one that is uniform for all of the tenants that you serve? As remember, you don't want different rules for different folks. That's just a recipe for disaster. You're basically being asked for a discrimination lawsuit. But if you have the same plan in place for all of the tenants that you lease to, you're much less likely to be hit with some kind of discrimination claim, or at least you'll have much more proof that your method of doling out notices and filing evictions is the same for everybody. Now, if you've watched any of my videos in the past, you know that I commonly refer to a 1-3-7 approach. One is it's okay to forgive. It's okay that if your tenant does something out of character that has never happened before and is not likely to be repeated, that you pardon that one breach one time within a 12-month period. If you're doing this early in the process or repeatedly in the process, you're just not doing it right. Again, it's okay to forgive once. Sometimes things come up and they can't be handled in any other way. It may not be absolutely essential that you evict them, and so you let it pass once. But if you're having to do it more than that, that's an indication that it's just not a good fit. So I wouldn't advise that you do it more than once. Certainly not super early in the process, and certainly not repeated. One time within a 12-month period is usually okay. The 3, however, is a 3 strikes and you're out policy. And what this means, this is specifically for non-rent related lease violations. You might have someone who's simply not dragging in the trash cans when they're supposed to, and you're getting letters from your homeowners association, or perhaps they've done damage to one of the walls inside the house while they were moving furniture, and they never either paid for that damage to be repaired, or they never reported it to you. Maybe they have an unauthorized pet or an unauthorized occupant, and you've issued notice and they simply haven't corrected that behavior. In any of these events, you're issuing notices of default, and whether you have 3 separate defaults that have occurred and have not been cured, or you have the same thing that you've issued notice after notice after notice for, and the tenant simply is not rectifying, a 3 strikes and you're out policy is a much stronger position than if you try to move forward with an eviction based on one infraction. When there's a rent-paying tenant and you've got one infraction, it's very likely that they go before the court and say, Your Honor, I took care of that yesterday. I don't see why we still have a problem. And in that situation, the court may also not see a problem. However, if it's been on repeat and it took you 6 weeks to get them to finally do the thing that you've asked, or they show up to court and say, I took care of it yesterday, your petition to the court could still be, yeah, but Your Honor, it took me 6 weeks of constant notice, and now that they've got it, I don't have confidence that they'll keep to the other requirements of the lease, and so I would like possession. Much stronger argument when you've got more than one incident. Again, a weaker argument when it's just one and it's already been cured. That doesn't mean that you can't evict or that you shouldn't evict tenants who simply do not follow the rules. We believe that these kinds of tenants will ultimately lead to economic trouble, even if they're paying the rent right now, and so they are a high risk and probably should be removed. Now, the 7 in my 137 plan has to do with the number of days you're waiting before you issue a notice to vacate when your tenant has not paid 100% of your rent or other fees owed under the terms of your lease. Now, it's important to know that if you've got an instant of partial payment, that you know how to use that partial payment to reflect that only rent remains unpaid. Now, I'm speaking specifically from the state of Texas, but this rule applies in many states. Many courts will not allow for an eviction unless the matter has to do with a matter of unpaid rent. In Texas, if a tenant owes a specific amount for rent, a specific amount for utilities, a specific amount for some other non-rent matter, and if you apply all their payment to rent first, well, guess what? You may not have a rent balance left to present to a court in an eviction filing. However, another thing that exists in Texas and exists in most all states is the ability to include in your lease an application of funds clause. And what this allows you to do is to apply payment to non-rent obligations first. If you can do this, then you can cover the utilities and cover the late fees and cover the pet charges or any of the other miscellaneous fees that come along due at the time of rent, and then whatever amount is left over goes to rent. And if that sum is insufficient to cover everything that's due at that time, guess what? By applying the payment first to the non-rent obligations, you leave only a balance of unpaid rent. And this is key when you're presenting your case to the court that no, it's not utilities, it's not late fees, it's not pet charges that are owed, it is a balance in unpaid rent. That those charges got paid and that in accordance with your lease, they are paid first. Don't carry over charges month after month after month and then expect the court to bail you out. In Texas, for sure, that simply doesn't happen, and that's the same in many other states. Utilize your application of funds clause accurately, and then you can move forward to eviction and again minimize those eviction losses. But if by day 7 you have not received 100% of everything that's owed after you've applied, again, any partial payment to non-rent obligations, you should be issuing a notice to vacate. And at this point, it should be serious that you fully intend to file your eviction if the tenant does not leave within the requisite number of days in your notice. Now, those days are going to vary depending on your legal position, on your goals, and on the rules of your local jurisdiction. And so pay close attention to those numbers. They are important. But right now, we're more concerned with the fact that you are sending notice with the intent of filing an eviction if the tenant does not vacate. Now, you may be asking, well, Ernie, I've done this before, and the tenant has come to me in tears and able to pay everything that's owed. They're able to pay all of the late fees. They're able to pay all of the pet charges, the utilities, and everything 100%. They just can't do it until the 10th. If that's the case, you have to understand clearly that allowing them to do this is just going to cause harm for the following month. If they can't pay it until the 10th this month, chances are next month it'll be the 12th or the 13th, and the month after that it'll be the 15th or the 16th, and then deeper and deeper and deeper into the subsequent months until they're now 2 months behind in rent. This only creates a cascade of future problems, which I encourage you to deal with in the present, because we know that eviction is not going to be handled in the next 2 weeks. But what will be happening in the next 2 weeks? You got to start thinking about that next month's rent. And so the only time that I would say it makes sense for you to accept the rent after you've gone so far with this tenant is if the tenant is willing to pay, yes, 100% of the present month, all of your court costs that you've incurred so far, and the next month's rent. Because unless they're able to do that, all you're really doing is kicking this problem down the road. You're not really solving the problem, you're just pushing it forward by accepting that amount now with the understanding that next month is in jeopardy. You're just fooling yourself into a false sense of temporary cure. You are just going to have another default right around the corner, and you'll have to do the whole thing over again. It's not wise. Instead, push forward with the eviction. And if they are able, before that eviction trial or before the eviction judgment is finalized, if they're able to catch up even into the subsequent month, then you can discuss full and final resolution. But if your next month is in jeopardy and cannot be or will not be paid on time, there's no reason for you to let up on that eviction, because again, you're just going to be there in the same position. The next month, you're better off breaking ties and moving on to a better fit. Remember, your tenant is loudly expressing to you, I can't afford to live here, especially if they have no mechanism of setting the ship back, of getting the train back on the tracks, whatever metaphor you want to use. If they simply can't accomplish it, it doesn't make sense to let them try. Now, none of this means anything if you're not actually issuing written notice. In Texas, it doesn't matter if you called them 15 times, if you texted them 11 times, if you just walked up to the door and had a really good chat. None of those things actually matter. They don't constitute proper notice. They certainly don't constitute a notice to vacate. If you want to make sure that your eviction filing is set up for success, make sure you're getting your notice to vacate right. That is absolutely fundamental. But that's not the only notice you should be delivering properly, and it's not the only notice you need to pay attention to. Along with notices to vacate, you should be issuing notices of default every single time your tenant violates the lease. Again, it's not enough to just give them a call. It's not enough to just, well, I'm not real excited about this. You should issue a notice in writing to your tenant in accordance with your lease. That being said, what does your lease in your local jurisdiction allow in terms of proper notice? In Texas, you're limited with how you're supposed to validly deliver a notice to vacate. I suggest, and we preach this all the time, to deliver your notice to vacate, you should be sending it by regular and certified mail. In Texas, that's the gold standard, and it's true in many other jurisdictions across the country. And whether that works for you or not is totally up to you. We like it because it's easy to track with the certified mail. It's easy to prove with records of payment of the mailing. We don't have to prove that they got it, but we generally can prove that too. The law, however, obligates us to demonstrate that we actually sent it. And by doing it in this way, we can do it every single time. In Texas, we are allowed to deliver other notices in other ways. A notice of default, a notice of non-renewal, a notice of termination can all be issued by regular and certified mail. But if the lease allows notices to be delivered by email or by text or through a tenant portal, those are all viable options. In fact, when it comes to email, we suggest that you collect as many emails as you possibly can. If there are 2 tenants and both of them are employed, guess what? There's probably 4 emails there on the table. And if you're taking none of them down as official methods of notice, you're just dropping the ball. Take a work email, take a personal email from each tenant who signs, and then guess what? Now you've got access to, again, their employer, should it come to tracking them down and finding out exactly how to serve them in some subsequent matter, should that need arise. But definitely get a work email, get a personal email, and then get permission in your lease to contact them by text whenever it is necessary. This way you can establish to the court that you issued notice and what that notice was. Now, between me and you, the least likely of these to be acceptable by the court or to be professionally drafted is that text. So common communication by text is perfectly fine, but I would reserve email and paper letters for notices that you plan to present to a court. Get in the practice of delivering an official notice, whether it's a notice of default, a notice of termination, a notice of non-renewal. Get used to issuing those in some kind of letter form whenever possible, or in a professional looking email form every time it's possible. In fact, your position should always be, what is this notice going to look like in front of a judge when I'm presenting it in a case to recover possession of this property? If you're sending notices with poor language, unclear demands, or just straight rudeness, and you would be embarrassed to present this to the court, don't send it. Remember, you're running a business, and so you should send your notices in a business-like manner. But you're sending notices not just to the tenant. Remember, you should be sending notices with the judge in mind also. So make sure, if your intention is to prove, Your Honor, I gave notice for them to cut their grass on a regular basis. I gave notice to them that I would be billing them for that broken window that they caused on the property that I paid to repair. I'm giving them notice that the lease will come to an end on December 31st because it's been on month to month, and I want the property back. If you can't demonstrate to the court that you adequately sent this notice, you may not be able to recover possession the way you'd like in the time frame that you like, which ultimately leads to losses. So to diminish your losses, make sure you start off with good notice every single time. There is no such thing as too much notice, but there's definitely inadequate notice that happens all the time. If you're sending a notice that just isn't getting across, if you're not sending a notice in a proper format, or if you're not clear in your notice and you can't prove that it got there, or you can't prove that you actually sent it where they asked to be notified, all of these cause notices to crumble, which cause cases to crumble, and which cause loss to you. You can minimize these losses, number one, by noting before you ever have to issue a notice that the notice you plan to issue in the future is a good notice. One way to do that is to seek out legal counsel for your jurisdiction to find out, hey, if I do want to issue a notice of default, a notice of non-renewal, a notice of termination, or a notice to vacate, are the notices that I have, these prefab notices, going to get the job done? Landlord tenant attorney can help you with that, but there are other people out there in your circle, and I hope you have a circle of property managers, investors, and landlords who can help you out. But you want to make sure that the notices you're delivering are potent enough to accomplish your goals. Additionally, you want to be able to prove that they got there. Again, for us, it's nonstop every day. We're issuing notice by regular and certified mail. However, when we have a client whose lease includes personal email, work email, email to multiple tenants, text, we utilize all of those as well. Not because it makes our notice any stronger, but what it does do is it diminishes the threat that the tenant is going to claim, I never got that notice, when we can say, Your Honor, we delivered it in 5 different ways, and here are the ways that we did it. By being able to demonstrate our diligence to deliver notice to them, it's less likely that that tenant is going to be able to convince the court that they never actually got the notice. We like to eliminate that threat right from the beginning by sending notice in a more than necessary way as a demonstration of our diligence to get the message to the tenant. Now, for those of you who are just starting out or maybe just don't have a whole lot of experience with the eviction process, I have an offer for you that we are making available to all of our clients, particularly for those in Texas. If you have rental property in the state of Texas and are issuing notices or would like to learn a better way to issue notices and file evictions and even handle eviction appeals in the state of Texas, then you may want to check out our eviction course. There's a link in the description below, but you can also check out attorneyeg.com/EV for more information on that eviction course. We walk you through the process of your notices, of filing, and even the kinds of things that you can expect at trial and on appeal. If you would like a course where we go step by step from notice to judgment to help you recover your property faster, I strongly encourage you to check out attorneyeg.com/EV, our Texas eviction course from start to finish. Again, I'm going to walk you through multiple multiple modules. I give you samples of your notices, samples of an eviction petition, and plenty of resources along with my step-by-step training to help you file your own eviction with success. If you need more information, feel free to send us an email at info@attorneyeg.com and check us out at attorneyeg.com/EV for information on our Texas eviction course. Evictions can be big and scary, but if you go into your landlording business already knowing what an eviction is like, already knowing when you're going to send notices, and already knowing what good notices are and how best to deliver them, you're ahead of the game and you're less likely to be caught unaware, which will inevitably result in better management of your tenants, which will result in fewer evictions, which will ultimately result in less amount lost from a tenant who's simply a bad fit. By knowing how to anticipate the fact that evictions will occur and working diligently that only in the event where they absolutely must occur are they happening, and they're happening quickly, or you're preventing the eviction by sending out adequate notice, and you know that the notices you're sending are rock solid and will get the job done. All of these steps together accomplish your highest goal, which is to maximize your profitability as a landlord. And I hope that along with today's video, you're checking out other content that we provide. In fact, YouTube seems to think that this video right here is the next best thing for you to watch. I strongly encourage you to watch it and all the rest of the content on our channel. And until next time, landlords, happy leasing.